You said 4 words. That's all it took. 4 words. And now you're sitting in the back of a patrol car, your firearm is being catalogued as evidence, and a prosecutor is already building a case around what came out of your mouth in a 60-second roadside conversation. No force was used, no crime was committed, you were polite, you were cooperative, you thought you were doing everything right, and you still destroyed yourself. I've watched this happen, not once, dozens of times. Good people, law-abiding gun owners, people who had every legal right to have that firearm in their vehicle, who lost everything. Their carry permit, their right to own firearms, their job, their reputation. Not because they did something wrong, but because they said something wrong. Today I'm going to break down exactly what that looks like, why it happens, and what you need to know before you ever get pulled over again. Because if you carry a firearm, or if you keep one in your vehicle, this video may be the most important 15 minutes you spend this year. Stick with me. There's something in the second half of this breakdown that most gun owners never hear. And by the time we're done, you're going to think about traffic stops very differently. I've spent years inside the criminal justice system as a defense attorney, as someone who studies Second Amendment law at a granular level, and as someone who has seen how fast a lawful gun owner becomes a criminal defendant when they don't understand how these interactions work. I'm not here to make you afraid of police. I'm here to make you dangerous in the best possible sense, legally prepared, legally protected, and legally intelligent. There's a difference between being cooperative and being self-destructive. Today, I'll show you exactly where that line is. Here's the reality most people don't want to sit with. The roadside environment is one of the highest risk legal moments in a gun owner's life. Not because cops are bad, not because the laws are always unfair, but because of how human psychology, legal doctrine, and the pressure of the moment collide at that driver's side window. You're stressed, your heart rate is elevated, you want to be seen as cooperative, you want this to be over fast. And in that mental state, you start talking, you start explaining, you start volunteering, and that is exactly where it falls apart. What's at risk here isn't a fine. What's at risk is your carry permit, which in most states can be revoked on the basis of a single arrest, not even a conviction. What's at risk is your right to own firearms at all, depending on how charges get classified. What's at risk is your employment, especially if you work in law enforcement, security, healthcare, or any field that does background checks. And in some situations, what's at risk is your freedom. This isn't theoretical. Every week across this country, someone who did nothing illegal walks into a courthouse because they couldn't stop talking during a traffic stop. Let's talk about why. Part 1, the disclosure trap. Most states have what are called duty to inform laws. Some require you to proactively tell an officer you have a firearm if you're carrying. Others only require you to disclose if asked. A handful have no duty to inform requirement at all. Here's the issue. Most gun owners don't actually know what their state requires, and many who think they know are wrong. They heard something from a friend, read a forum post 3 years ago, or are operating based on laws that have since changed. If you do not know your state's exact duty to inform status right now, that's a problem you need to fix before your next drive, not during a traffic stop. But here's where it gets more complicated. Even in states where disclosure is required, the law typically says you must disclose that you have a firearm. It does not require you to tell the officer where it is, how many you have, why you have it, where you're going, where you've been, or anything else about your day. And yet, when people disclose, they almost never stop there. Officer, I do have a firearm. It's under the seat. I've had my permit for 3 years. I was just coming from the range. I've never had any issues. Stop. Just stop. Every single one of those additional words is a gift to the prosecution. Every detail you volunteer is a new thread a prosecutor can pull. You just told the officer where the gun is without being asked. You just told him you were at a range. Now he's wondering if you fired it recently. You just established a pattern of behavior he can use in a narrative. You didn't lie. You didn't break the law. But you handed over information that can now be used against you if anything about this stop goes sideways. Here's one that almost nobody talks about. Let's say the stop seems routine. You disclose your firearm. The officer asks to see your license and registration. Then, And this is the moment. He says something like, "Mind if I take a look at that firearm?" Or, "Do you mind stepping out of the car?" Or, "Would you be comfortable if I just secured that weapon while we talk?" These are requests, not commands. And most people, being cooperative, wanting to de-escalate, not wanting to seem like they have something to hide, say yes. The moment you consent, you have voluntarily expanded the scope of that stop. What was a moving violation is now a consent search, and anything found in that search, anything, can be used against you. A round in the chamber when someone claimed it was unloaded, a magazine that exceeds your state's capacity limit, a prior restraining order that you forgot about that disqualifies you from carrying. Here's the catch: you had the right to say no. In most circumstances, absent reasonable suspicion of criminal activity, you have the right to decline a consent search of your vehicle. That does not mean you resist. That does not mean you argue. You say calmly and clearly, "Officer, I want to be respectful and I'll cooperate fully with anything you're legally required to do, but I don't consent to searches." That's it. That's the whole sentence. Most gun owners don't know they can say that, or they know it intellectually, but in the moment, the social pressure of standing at a roadside in front of a uniformed officer with a patrol car's lights flashing behind them overrides everything they've learned. This is why you have to mentally rehearse this before it happens, because when it happens, you won't have time to think. You'll only have time to react. And whatever you've trained your reaction to be, that's what comes out. Now I want to talk about something that trips up even smart, experienced gun owners. This is the reframe I promised you at the top. Most people think self-incrimination means saying something dramatic, saying, "I was going to use it," saying, "I knew I shouldn't have that," saying something that sounds like a confession. That's not how it usually works. Self-incrimination at a traffic stop usually sounds completely innocent. It sounds like, "I didn't think it was loaded. I forgot I had it in there. I didn't have my permit on me, but I do have one. I usually keep it in my holster, but I took it off earlier." Each of those statements, while potentially true, is a legal problem. "I didn't think it was loaded" introduces the concept of negligence. "I forgot I had it" undermines your claim to lawful knowing possession in certain charge frameworks. "I didn't have my permit on me" is an admission of a potential violation in states with carry permit requirements. And "I took it off earlier" raises the question of where, when, and why, questions you just invited. You did not intend to incriminate yourself. But in a courtroom, intent doesn't change what was said. Statements get introduced, juries hear them, and what seemed like harmless context becomes prosecutorial ammunition. The Fifth Amendment exists precisely because the framers understood something about human nature. People will talk. People will explain. People will try to help themselves out of situations by talking their way through, and in doing so, talk their way into much worse ones. Invoking your right to remain silent is not suspicious. It is not rude. It is not an admission of guilt. It is a constitutionally protected right that every single person in this country possesses, and there is no legal penalty for using it correctly. Let me give you the practical framework. This is the part you need to carry with you, not on paper, in your head. When you're pulled over and you're carrying a firearm, here's the structure. First, get stopped safely. Pull over promptly. Turn off the engine. Turn on the interior lights if it's dark. Keep your hands on the wheel and visible. Do not reach for anything until asked. The officer's first concern is his own safety. Help him see that you are not a threat. Second, if your state requires disclosure, disclose. Use a short, clear statement. "Officer, I want you to know I have a valid carry permit and I am carrying a firearm." Then stop talking. Do not volunteer where it is unless asked. Do not tell him anything about your day, your destination, or your history. Third, answer questions about your identification and registration. You are required to provide your license, registration, and insurance. That's a legal obligation. Everything else, where you're going, where you've been, what you were doing, is optional. You can simply say, "I'd rather not answer questions beyond what I'm required to provide." You're not obligated to be chatty. Fourth, if asked to consent to a search, decline clearly and without aggression. State that you don't consent. If the officer has legal authority to search, he will search regardless of your consent. Your refusal doesn't stop a lawful search, but it prevents an unlawful search from being treated as voluntary, and it preserves your legal options afterward. Fifth, if you are detained or arrested, stop talking immediately. Request an attorney. Not in a hostile way, not in a dramatic way, calmly. I'd like to speak with an attorney before answering any more questions. Then say nothing else. Nothing. The conversation is over until your lawyer is present. That's the framework. 5 steps. Memorize them. So let's pull back for a second and recognize what we've actually covered, because there are a few threads here that connect. You can have every legal right on your side, valid permit, lawful carry, lawful possession, and still create the conditions for your own prosecution by what you say in the first 60 seconds of a traffic stop. The disclosure trap turns compliance into oversharing. The consent contamination turns cooperation into a search you never needed to allow. And the admission in disguise turns casual explanation into prosecutorial evidence. The law didn't fail you. You talked yourself into a corner. Now, here's one more thing I want you to hear, and this is the part that I think is most underappreciated. Even if charges never come, even if nothing ever goes to a full prosecution, the words you speak at a traffic stop can follow you. Statements you make to officers are documented. They go into reports. Those reports are accessible in certain licensing hearings, in civil suits, in future background investigations. If you ever apply to work in law enforcement or private security, if you ever go through a custody dispute and someone claims you're an unsafe person, if your carry permit comes up for renewal and there's a flag in your file, that harmless conversation, the one where you just tried to be cooperative, where you explained everything, where you were sure you hadn't done anything wrong, that conversation can still find you years later. This is why the lawyers who carry firearms, and yes, there are many of us, are the most tight-lipped people at traffic stops. Not because we're hiding something, because we understand exactly what language does inside a legal system. Here's where I land. You have rights, powerful, constitutionally grounded rights. The right to keep and bear arms, the right to remain silent, the right to be free from unreasonable searches, the right to an attorney. But rights are not automatic. They don't protect you passively. You have to invoke them. You have to know when and how to use them. And you have to be prepared before the moment arrives, because when the lights come on in your rearview mirror, the time for preparation is over. One wrong word does not guarantee disaster, but one wrong word is often all it takes to turn a routine stop into a nightmare that follows you for years. The best thing you can do for yourself, your family, and your rights is this: know your state's disclosure laws, practice the 5-step framework, and commit to speaking less when it matters most. Silence is not guilt. Silence is strategy. And sometimes, strategy is the only thing that keeps you out of a courtroom. If this is the kind of breakdown you want to stay ahead of, Second Amendment law, self-defense rights, real legal analysis of what these situations actually mean, hit subscribe and turn on notifications. I put out content specifically for people who carry, who own firearms, and who want to understand the law well enough to protect themselves inside it. One last thought to leave you with. The police officer at your window is doing his job. The prosecutor who reviews the report later is doing his job. The only person in that equation whose job it is to protect you is you. Know your rights. Use them quietly. Walk away free.